1-800-228-6540. That's 1-800-228-6540. 1-800-228-6540.
South Florida's News Talk Connection.
610
100.3
WIOD.
It's the Car Guys, wrapping it up for another Saturday afternoon. I'm Jerry Hester. He's Tony Stampone. And then in the middle, playing with his phone, Robert Ladaga, service director here at most of the dealerships. Anyway, 866-610-6397, star 610 for AT&T Wireless. Let's get to the phone. Steve is on line 2. What's up, Steve?
I am considering purchasing a classic car, almost classic. 1990 to 95 Corvette, but the ZR1 model. Are you familiar with the ZR1?
Yep, that's the one that has the overhead valves and the absolutely motor built by Yamaha.
Really?
Yep.
Basically, overhead cam, four of them.
Yep.
And motor built by Merc Cruiser.
Merc Cruiser. I thought Yamaha was involved with that as well.
That's close. That's close. My question to you is,
Yes.
Do you think I'll be able to find anybody to work on this mechanically if I'm starting to have trouble?
Actually, I do know a Corvette guru, so if you do buy one, actually the Corvette guru that I know owns one. And I haven't talked to him in a little bit, but I'm sure I could still get a hold of him.
Okay. Well, how do I find out who he is?
I'll take a number down that you could call me on Monday. I'm going to see if I could reach him over the weekend. And if he's still working on cars like he did, and he had his own private shop, and that's all he worked on. It's just Corvettes.
Well, that'd be wonderful, and I thank you for your help.
Not a problem. Take the number down. My number is 954-443-2332. That is the service number for Lexus Apartment Pine. Just ask for me Monday. And I would definitely try to get you in touch with this gentleman.
Did you find the car yet?
No. Give me your name again, sir.
Robert.
Robert. All right. No, I didn't find one there.
Did you find one for him, Tony?
Yeah, there's
there's a 94. There's a 94 on eBay, ZR1. It's a red one.
I saw that, and it's been on there for quite a while because it's priced so high.
There's not that many of them, but good luck in your project, sir.
All right, thanks, Steve. Good luck. Give Robert a call on Monday, and he'll hook you up with the Corvette guru.
It's a big money vet. This is a big money vet.
It's a
limited production of those cars. They didn't make that many.
This car's like $50,000. Wow.
So what else is special about it, Robert?
It's not your typical V8 engine.
Uh-huh.
It's actually overhead cams, overhead valves, dual cams. So it was so far ahead of its time. The engine design. It's basically what the Lexus, the design of the Lexus engine now.
Oh, okay.
Very, very close to it. And you know what? It was very fast for its time. It's actually, and they did not make a lot of them.
No.
Which is the cool part. So the gentleman is right. It will be a collector.
This one has 400. This one has 410 miles on it, and 95. Talk about a car that's a perfect car.
That's
a brand new car. Wow.
It's not even broken in. Not even close. And it looks good.
Yeah.
If you like red. Not crazy about red. Anyway, the figures are out for February. The mothership had a good month. Toyota division, number one retail brand, period. 29,000 Camrys last month in February. 25,000 Corollas. This is just in the United States. Toyota trucks up 3.5%. 4Runner up 17%. Highlander up nearly 30%. RAV up 23%. Tundra 8%. Lexus overall 19% up year to date, February to February. That's huge. The GS 42% over last February. And it was still new then. This version of the GS. RX, almost 6,000 RXs were sold in the United States last month, and the GX posts triple-digit gains. The GX. It's overtaken the LX by far. It's getting close to the RX. You see a lot of the GXs on the road now. I mean, that's strong. That says a lot. I mean, every month, I get these, and every month I'm still surprised at how much it's better than last year. And last year we thought was the best year ever. It was the best year ever.
Jerry, you're talking about looks, performance, pricing. I mean, it's all of it. How can you go wrong?
Yeah, I think Tony said back in December, how are we going to beat this year? Well, right there. That's how you're going to beat this year.
And it's cool. It's cool how Toyota's committed to so much production in the United States with all the plants they have, and all the product they have. Employing
Kentucky, Mississippi, Illinois,
employing
here, there, everywhere.
Yep, that's great. That's a great commitment.
And they're going to be building more pretty soon. Was it the ES that's going to be built here?
Yes.
Yeah. So, and they're going to be more. They're going to be adding millions and millions of dollars to the economies of these small towns, because they don't put these things in Boston or Chicago or Miami or L.A. or New York. They put them in small towns where there's lots of land, and that town depends on that factory, that plant.
It wouldn't surprise me if down the road Toyota will put a factory in Detroit. It wouldn't surprise me.
Wouldn't surprise me at all. I mean, I'm sure lots of parts are made there now.
Yep. It would not. And you know what? If there's a city that would benefit from Toyota coming in, it would be that city.
Yeah. I mean, it's just terrible what's happened to Detroit. Right. I mean, with all the history of the automotive history and everything. But, they're resilient.
Yep.
They'll bounce back, and the Lions got better.
Like Rocky said, I got one more round. One more.
One more round?
Yep.
One more? Well, it's time to reload. All right, the Home Mortgage Law Show is up next, featuring that Lexus of Pembroke Pines car driving attorney, Shay duPont. You get out and enjoy this day, will you? We'll take a break and be back next Saturday at 1 with lots more of the Car Guys.
Keeping you connected to Miami, South Florida, and the world. This is News Talk 610, 100.3 WIOD.
Available anywhere you go on the iHeartRadio app. Download it now.
Your news starts now.
Good afternoon. Partly cloudy skies at the moment. Our temperature's around 80 degrees, and Will Altoff, new ideas as to where that missing Malaysian airliner may have gone, and rapper Chris Brown in trouble with the law again. Those stories and more, but first, Marlene Munoz has the latest from Miami's Magic City Casino Traffic Center.
Thank you, Will. In Miami-Dade south on US 1, minor delays due to a crash blocking the roadway before Southwest 184th Street. Also slow traffic on westbound Dolphin from Lejeune Road to the Palmetto. And in Broward, stop and go on north on US 1 between 595 and State Road 84. I'm Marlene Munoz, News Talk 610, 100.3 WIOD.
Partly sunny this afternoon. We'll top out at 79. Patchy clouds tonight, the low 69. Then for tomorrow, intervals of clouds and sunshine, high 82. Monday, some sunshine, windy, thunderstorms are possible, high 85. I'm AccuWeather's John Fear for 610, 100.3 WIOD.
It's 82 right now in Miami Beach, 80 in Weston at 2:01. New developments coming out of Malaysia indicating where authorities are now focusing their investigation into a missing 777.
The Malaysian authorities have refocused their investigation into the crew and passengers on board.
Malaysian Prime Minister Najib Razak stopped short of calling the action an outright hijacking, but did say that someone on board had knowledge of how to operate tracking and communication equipment. Razak said the deliberate action could have taken the plane anywhere from Thailand to Kazakhstan, south to Indonesia. Secretary of State John Kerry warns that there will be consequences if Russia doesn't change course in Ukraine. Kerry saying the U.S. will not recognize the results of Sunday's Russian-backed referendum, calling it a violation of international law. Today, Russia vetoed a UN Security Council measure to that effect, killing that measure. With just a little over 2 weeks left to sign up for the Affordable Care Act, Congresswoman Debbie Wasserman Schultz is pushing for enrollment this weekend. So far, about 450,000 Floridians have signed up, over 4 million nationwide. DWS says the overall number of uninsured is at the lowest point in quite some time.
Down to 15.9% now. That's the lowest rate that surveys have measured since 2008.
Wasserman Schultz will hold a sign-up event from 9 to 2 tomorrow at the Broward College campus in Davie. Another warning for all of us to be careful about who we give our personal information to. South Florida, the nation's capital of ID theft and IRS fraud. Once crooks have that information, they file a phony tax return, get a refund, and we may not even know it's happened until filing taxes with the IRS. Experts urge you to keep an eye on your credit report and bank account online. You can also sign up for identity protection services. Troubled rap star Chris Brown's been busted again. This time, police in California picked him up on charges of probation violation, charged because he left a court-ordered rehab center. Los Angeles Deputy Sheriff Amber Smith.
The warrant was related to a 2009 case for assault with a deadly weapon and criminal threats.
Brown was being treated for anger management and heads to a probation hearing Monday in Los Angeles. Toe to go back for another St. Patrick's Day weekend, just in case your partying exceeds your driving ability.
The only program that will come get you and your vehicle and tow you both home safely, free of charge, no questions asked.
That's Joanna Newton of the AAA, who urges you to program their number and a taxi number into your phone before you head out. We've got all that information posted at WIOD.com. And allergy season seems to be hitting a peak in South Florida. Cars appear dusted with pollen. Doctors' offices filling up with sniffling, sneezing patients. Hollywood allergist Dana Wallace says the past 2 weeks have been busy.
We usually don't see much seasonal change in Florida. It's pretty even. But people have been coming in complaining of acute symptoms of eye allergies, itchy, red, teary, as well as nasal symptoms.
She says the allergies are most likely related to grasses in the area. Next update at 2:30, the Home Mortgage Law Show is next. I'm Will Altoff, News Talk 610, 100.3 WIOD.
Listen, if you missed a show, if you missed a conversation, if you missed the results of one of our surveys or one of our videos, it's all there for you at the Sanchez blog. Check it out. RickSanchezShow.com.
Rick Sanchez, weekdays 10 till noon on WIOD.
This report is brought to you by TrueCar.com.
Buying a car can be a very stressful experience. TrueCar.com can help. They have the most comprehensive new car pricing information available to make sure you never overpay. Save time, money, and never overpay. Visit TrueCar.com today.
Buying a car is stressful, and with TrueCar.com, those days are over. TrueCar.com is the new way to buy a car. You know, my wife and I were expecting our second child, and we need a bigger car. I mean, let's face it, with the stroller, the groceries, everything else, you need like an SUV or something. So that's what we were looking at, and the first place we went to was TrueCar.com. TrueCar.com helps you get rid of the fear that you might overpay. Once you know the car that you want, like we were looking at a Tahoe, then you go to TrueCar.com and you check it out. You'll know when you get a fair price because you'll see what others paid for the car that you are looking for. And in case you're wondering how TrueCar.com works, TrueCar.com analyzes what people are paying for their cars in your market and shares it with you so you never have to overpay. TrueCar.com has the most comprehensive new car pricing information available. And thanks to TrueCar.com, I know that I'm saving money, and that's important, especially when you have a family that's growing like mine. You'll never want to go back to the old way of buying a car. TrueCar.com is the new and better way to buy your car. Go to TrueCar.com.
7,000 high school students drop out every school day, stack their desks one atop the other, and it's a pile more than 17,000 feet high. Go to boostup.org and learn how you can help. Brought to you by the U.S. Army and the Ad Council.
The Home Mortgage Law Show is a paid program and is intended as a resource guide for education, information, and entertainment purposes and is not intended to provide specific legal advice. The information that you hear should not be used as a substitute for competent legal advice from a professional attorney. Hiring of an attorney is an important decision which should not be based on advertising or the information that you hear today.
Good afternoon and welcome to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont and Regal Tax Advisory Group. We're with you every Saturday afternoon from 2 until 4 on our flagship station, News Talk 610, 100.3 WIOD and 970 WFLA, both which you can find on the go Whether you're doing your groceries, whether you're at the gym or fixing your car or doing your hair, just download the iHeartRadio app. It's totally free. You can find us also on Facebook, The Home Mortgage Law Show, brought to you by Morris DuPont, PA. And of course, on Twitter, it's Morris DuPont. And we have attorneys, Will Morris, Shay DuPont, and Michelle Hanash, our bankruptcy attorney, here for you. The phone line, toll free to call the show, 866-610-NEWS, 866-610-6397. AT&T Wireless customer, star 610. Will, I can't believe what a great day we're having.
Oh, it's an awesome day, isn't it, though?
It is.
And here we are, stuck in the studio. But you know what? It's always a privilege and a pleasure talk to the listeners, even though it's a beautiful day, and even though we should have otherwise be outside, enjoying the beautiful day. I think I consider it personally a pleasure and a privilege to meet with and talk to people about their mortgage issues, about their home issues, about their credit issues, about their bankruptcy issues, whatever consumer issues they may have. It's always a privilege and a pleasure to try to help somebody out, to sit them down and listen to their story, and then at the end, give them options they might have not otherwise thought of. And, we always talk about having the free 1-hour consultation that's offered by the law firm of Morris DuPont.
Right, but we don't say 1 hour
anymore.
anymore.
No, the truth of the matter is, Natalie, it's not an hour. It lasts however long it takes to make that person understand what their circumstances are, and more importantly, what their options are. How many times people come in and think, well, gee, I'm facing this foreclosure issue and maybe I need to file for bankruptcy. And maybe they do sometimes, but most of the times they do not. There are other options available. They could do a strategic default. There are a whole host of loss mitigation options available to them. There's a short sale. There's a modification. There's a deed in lieu. There's a short payoff, a whole host of options that are available to homeowners. And just because they're facing financial crisis and just because they're falling behind in their mortgage doesn't necessarily mean that they're out of their house and there's nothing else for them to do but pick up and move on. And we talk all the time about, these zombie foreclosures, Shay. We talk so many times about them. And it seems to be the latest subject in the news about the zombie foreclosures, about people who, because they're facing financial crisis, because they've gotten a notice in the mail from the bank advising them that they're in default, suddenly decide on their own to pick up shop and move out of their houses, thinking it's all over. There's nothing they can do about it. They've lost the house. It's all over. The truth of the matter is, until and unless a court of law says you've lost the house, until there's a final judgment and ultimately a foreclosure sale, you've not lost that house. The house is still in your name, and anything that goes on relating to that house is still your responsibility. So yeah, walking away is not an option. We talk about the zombie foreclosures. Well, Shay, the truth of the matter is, it happens on both sides. Sometimes banks file foreclosure actions, and because for whatever reason, maybe they lost the paperwork, maybe it fell through the cracks, for whatever reason, they don't pursue these foreclosure actions, and the actions stay in limbo. Then on the other hand, you have homeowners simply saying, look, I'm just going to walk away from the house and not do anything about it. And lo and behold, somewhere down the line, they start getting bills from the local municipality talking about, well, you failed to mow the lawn, you failed to paint the house, you failed to do this, and all these penalties and fines start adding up. And before you know it, these people who thought they've walked away from the responsibility have an even bigger financial responsibility because of these penalties.
Yeah, and the article that we were talking about that sort of triggered this conversation was actually based on a Reuters story that the Consumer Financial Protection Bureau was going to start focusing on these zombie foreclosures because of these empty properties. But Will, I didn't really like the tone of the article. I mean, it talked about really like the definition they used. The zombie foreclosures result when banks begin a foreclosure, even going so far as to send the homeowner a foreclosure notice, but then abandon it, failing to alert the homeowners who have often moved out that they are still responsible for their vacant properties. Well, I'm sorry. Look, very often I'm on the borrower's side. That's my job. But this article and some of the way that they talk about these zombie foreclosures, it makes it seem like the homeowner has no responsibility for themselves to understand the situation that they're in.
Right.
I mean, you don't just go out and, la-di-da, go borrow over $100,000 from somebody without kind of understanding what you're doing.
And understanding your responsibilities.
Your responsibilities. Right. And you shouldn't be walking away from a property that you have ownership, title to, and just act like, oh, whatever happens is going to happen.
Right.
And gee, it's not really my responsibility. Well, I'm sorry, folks. folks, but it is your responsibility. You can't just walk away from all of this responsibility that you signed up for. It doesn't work like that.
Right.
So, okay, fine. The Consumer Financial Protection Bureau can go and they can, focus on this and understand and address the issue of these vacant properties. But to me, it's, hey, homeowners, stand up and take responsibility.
Absolutely.
You cannot just walk away from these properties. You have a financial responsibility and really an ethical responsibility to resolve this clearly, to find a solution.
Well, separate and apart from all these other responsibilities, you've got a legal responsibility. I mean, what happens if something happens to that house? What happens if somebody walks in the property and breaks their leg? They can sue you. You are the owner.
Yep. Yep. So you have liability exposure, and you also have issues with your municipality, which is not going to appreciate you vacating the house and having it go into disarray.
Not to mention your neighbors who you're affecting their property value, because if a person goes and look at the neighbor's house and wants to buy it and see a property next door that's all run down and in a state of disrepair, they're going to think differently about what they want to pay for that house.
Right. And for goodness sakes, any listener of the Home Mortgage Law Show, I know none of you out there would do it because you understand what your different options are. You understand what your responsibilities are. You understand that you can do a deed in lieu where you can deed the property back to the lender and then they will become responsible for it. You can actually do a short sale and a new owner can come in, so there's no time that the property will be vacant. There's a consent judgment you can do in a foreclosure action. You can get a loan modification and possibly stay in that property. We're going to be talking about the 5th anniversary of HAMP and some of the wonderful things that the Home Affordable Modification Program has done for homeowners. So there's no reason for any listener of the Home Mortgage Law Show to ever be walking away from a property, because you know why? You're too educated.
Right.
You know too much to do something this silly, because to me, this is silly.
We've only been pounding in your head for almost 5 years
That's
now.
right. That's
Don't walk away. Don't
Yeah.
put your head in the proverbial sand.
And
this
Michelle?
issue comes up even in our bankruptcy context. Shane and I have discussed this many times, where even though you filed a Chapter 7, maybe you surrendered your property, you still have title to that property. The bankruptcy doesn't remove your name from the title. You still own it.
Right.
And sometimes obviously not our clients, but, we've definitely taken calls from listeners who just didn't understand that fact. They surrendered a property in a bankruptcy, didn't realize they had these municipal fines. They had homeowners association liability after the filing. So it's the same issue that crops up there.
Yeah.
You're listening to the Home Mortgage Law Show, 800-974-2712. 1-800-974-2712. Toll-free number for free consultation with the experts that will get your resolutions, your solutions, your options. 1-800-974-2712. If you can hear our voices, there are offices near you. Pick up the phone and check. 1-800-974-2712. Much more of the Home Mortgage Law Show right after this. You're listening to the Home Mortgage Law Show, brought to you by the law firm of Morris DuPont and Regal Tax Advisory Group. Our phone lines are open. Pick up and talk to the experts right here. 866-610-NEWS, 866-610-6397. AT&T Wireless Customer Star 610. Attorney Shea DuPont, Will Morris, and Michelle Hanash, bankruptcy attorney, here for you.
Michelle Hanash, bankruptcy attorney, here for us. Glad to see you, Michelle.
Thank you. It's good to be here.
And what are you going to be talking about today?
I think I'm going to be talking about some of these danger warning signs that clients come in and talk to us about because they waited too long to come in and seek some help. So we have two interesting stories on that front.
Nice.
Oh, okay, good.
Very good.
Glad to hear.
I think I'm planning a Rocky segment where somebody's going to come in, a client of Morris DuPont. We weren't able to help him because he waited until there was a sale date to come and meet with us. And we should have a Rocky segment with him too. I mean, it's not a success story, but it's a lesson.
Okay.
Interesting. We have a phone call. Jeff, welcome to the show.
Hi, Jeff.
Hi, how are you?
Good. What can we do for you today?
Well, I have a question. This is regarding a HELOC that I have on my home. And in a nutshell, the situation is that back in in 08, I did the same as everyone else. Had issues with my mortgage. My primary was I immediately went to try to get modification. Got that. That's been done. The mortgage has been current for 3.5 years now on the primary. I had two junior mortgages. One of them was extinguished under HAMP completely. and the other one persisted, and that's the one that I'm speaking about. This is a $75,000 HELOC that has not been paid since '09. Now, I attempted to do a modification with PNC at the time, who originated this loan, but that one never came through. And then this, as you know, how they continue to sell this to, I guess, different investors, and different service companies kept taking it over. So I've had probably 4 or 5 different servicers over the last 5 years.
Who's servicing it now?
It's a company called Prio, or DTA Solutions. It seems like that's one and the same company, and they kind of juggle back and forth. And I've been told that it's owned by a private investor.
Okay.
But the situation that I have, I've been offered a settlement. They've come in with different things. One is at 20%, and up until currently, I have not been able to do that. Just quite frankly, so it's never been settled. Now, the last payment on this was February of 2009. So my understanding is I have now passed the statute of limitations for them to, or at least I would have a defense of statute of limitations defense for any lawsuit, whether they come after me personally or if they were to attempt to foreclose.
Okay.
So I'm and now that we're in March of 14, the 5 years has passed. Obviously, the lien still persists on the home. So here is my question. Since I have the statute of limitations defense, at this point in time, I'm just sitting here with a lien that's persisting, and at some point in time, I'll either settle up with them or whatever the case may be. However, I'm currently pursuing a possibility of moving for a business opportunity in the Tampa market in the next 6 to 8 months. And my question is, right now there's about $7,000 worth of equity in the home, based upon, now this is based upon, the online valuation, that starts with a Z.
Yeah.
So the question I have is, if I were to sell the home, since I have the statute of limitation defense, the junior lien would obviously want to collect whatever they could.
Absolutely.
But if there were a deficiency, if there was a deficiency, which there would be at this point, does anything change with that statute of limitations? Is something re-upped, or am I still covered for them to pursue me for that deficiency from the statute of limitations from '09?
That's an interesting question.
That's a very good question, Jeff. Jeff, I just want to, number one, let's be sure folks understand when we talk HELOC, we're talking home equity line of credit. So you have a $75,000 home equity line of credit on this property. Tell me, what is the value of the first mortgage today?
It is $220 with a $20,000 balloon payment, so the total is around $240.
Okay, and what's the current market value of the property?
Around $250.
Okay, so when you say that you've got about $10,000 in positive equity, you're not considering the HELOC in that. You're considering just
correct.
the value of the first mortgage. So the second mortgage at most has $10,000 worth of secured equity in that property.
That's correct.
Okay, and you've gotten a $20,000 offer of or 20% offer of settlement, so about $15,000. But who's got $15,000 laying around, right?
That's correct.
Okay.
Now that could change in a few years if I didn't. One of my options is I just sit in the home, allow the lien to persist, and in a few years I end up settling with them. Another option is that I rent the home out and take a business opportunity out of town and rent the home out, not opening myself up to the liability of this deficiency.
Right.
However, if the statute of limitations still protects me, then I would just allow them to take, of course, whatever excess equity is left in the home towards that junior lien, and then they can't
Right.
pursue me.
Well, here's the thing.
That's my question.
Yeah, I think all three of us would have different answers
Right.
to this problem, but I'll let Will start
here's
because
what
I
I
know
think.
I've got an option too.
Here's what I think. I mean, based on what you're telling me, here's what I think. Now, the concept is the statute of limitations starts to run when all the elements of a claim are in place, right? Right? So you've got the statute of limitations regarding whether or not they could foreclose on you. That's a 5-year, and you're right on that. They can't because it's beyond the 5-year period, and they can't foreclose on it. And they probably can't come after you personally. However, as far as the deficiency go, the deficiency is only determined when the house is up for sale. It's determined the amount that is owed versus what the house was sold for. And to me, the last
snap.
element is what is the amount of deficiency we're talking about. That only occurs when the house is sold. So I believe that 1-year statute of limitation will burn you on that one.
Okay, so if at the time that the house sells, if there's a deficiency and he doesn't get it waived through the
Right.
short sale, then that second lender can come after him for the deficiency for 12 months.
It seems
from
that
the
way to me
date
because
of the
the argument
sale.
would be, look, I didn't know what the deficiency was until the house sold.
I don't see the logic in that. If
I
they
don't
can't
either.
take the house back regardless, that's a 100% deficiency. If they can't foreclose and they can't come at you personally, that's a 100% deficiency right there
but
that they can't.
we're talking about three separate causes of action. We have one cause of action for foreclosure, which is the 5-year statute of limitation. You have the other cause of action, which they could come after him personally on a note. That's another 5-year statute of limitation. You got the third cause of action, which is a claim for a deficiency.
But if they can't do either of the first two, I don't see how they would have a
I can
deficiency
see the argument going
claim.
the other way too.
Right.
You know?
But I think, Jeff, you're not even going to have to worry about the issues that both Michelle and Will bring up, because I believe that your best course of action, if you have to leave the area, and, Tampa's a great place to go if you've got to relocate. Love Tampa.
And what you're going to say, rent?
No, I'm going to say no.
Negotiate.
No.
Both
Ladies and
wrong.
gentlemen. Ladies and gentlemen.
Allow her to finish her thought.
Simple short sale with the deficiency waiver. I
There
don't
you
see
go.
why the second isn't going to waive the deficiency. The first is going to knock over to the second lien holder up to $8,500. The second lien holder is going to be happy to get the $8,500. Otherwise, they would get nothing because of the issues of the statute of limitations. And their attorneys are arguing the same issue. Does case law support us going after him for the deficiency or not? Better to take the $8,500 and run. So, Jeff, I think your best course of action is just to simply short sale the house, and it will be a short sale, even though you've got the $10,000 of positive equity
Because it's not enough to cover the second.
It's not enough to cover the second, and the real estate, even if he settled the second, the real estate commissions
Eat it up.
and the closing costs would eat up the $10,000 worth of equity anyway. So don't worry about selling the second. Just exit the property.
But if he did
Okay.
want to keep
That's
the property, if he wanted to keep the property, I don't, sometimes we negotiate release of liens for really, really not that much money when you look at the mortgage balance.
Yeah.
I agree. We're talking about 10%.
Right.
Right. So, very good answers, and that's what this question kind of perplexed me, and that's what I didn't want to re-up this. And to your point, Will, that's what I was concerned about, is that as you term it, another element. I was concerned that this would sort of re-up that, and so based on what you said, though, the statute of limitations on the deficiency is 12 months.
Right.
Okay. And but I understand what you're saying, Shay, is that, and I agree with you. Since they're already willing to settle for $15,000 right now, chances are they'd end up selling for $8,000-9,000
with a waiver of deficiency.
Right. It's
Okay.
$0 or $8,500.
Yeah. So it depends on whether or not the Tampa job really comes to fruition. Otherwise, you're probably sitting pretty. They're never going to, they can't now actually do anything against going against the property, going against you personally on the note. It's only when you want to sell or refinance that property that the second mortgage comes into play again.
And let me ask this one last thing, would be, just so that I'm clear then, so my understanding then of the 5-year statute of limitations for them to, let's say that I end up, this possibility of going to Tampa falls through, and I end up just staying in the home, which I'm happy to do. I am correct then, and this is my question, I am correct then in that the only recourse they have at this moment is to allow the lien to simply persist, because they can't come after me personally or foreclose, even if the home were to accumulate the $75,000 in equity at some point in the next 5 years.
Right.
They still can't do anything until at some point I'm selling the home.
Right. The short answer to that is yes. You're absolutely right. Because understand that. You know what? You want to hold on for a second? He's got interesting questions.
You're listening to the Home Mortgage Law Show, brought to you by Regal Tax Advisory Group, and more importantly, the Morris DuPont PA Law Firm, where you can find them just about anywhere. Just pick up the phone and call 800-974-2712. We're getting a couple more calls, but on the phone we have Jeff.
Well, before we go to Jeff, let's talk about where those locations actually are, Natalie.
Oh, perfect.
We're in St. Petersburg. We're in Tampa, Dadeland, Doral, Aventura, Fort Lauderdale, Plantation, Boca Raton, and West Palm Beach. So if you don't like calling us on the air, if you'd like us to talk about your mortgage, if you'd like to schedule a consultation, they're free. All you need to do is call the law firm of Morris DuPont at 800-974-2712. That's 800-974-2712 to schedule your free consultation with the lawyers at the law firm of Morris DuPont, including me. I'm going to be in the Tampa office next week, but this week I'm going to be in the Doral office. Looking forward to meeting each and every one of you that hears our show. Remember, the Home Mortgage Law Show, the website, homemortgagelaw.com. Easy to find us, easy to give us a call. We've got people in the office today, but we were on the phone with Jeff. Let's get back to it.
Hi, Jeff.
Hey, how are you?
And Jeff was talking to us. He's got a $75,000 home equity line of credit. He stopped payment in February of 2009. Bingo! 5-year statute of limitations has run for the lender to file a foreclosure action or to go against him personally on the note. But my partner, Will Morris, and bankruptcy attorney Michelle Hanage still have some ideas about exactly how this is all going to play out.
Right. You were talking to us about the statute of limitations on the first and whether or not you should just let the lien stay there. The truth of the matter is, even though, and you're right, even though they cannot foreclose on you or come after you personally, the lien on the property remains. And if the lien remains, if you ever look to sell that property, you would have to satisfy that lien in order to convince the bank to release the lien so you can then transfer clean title to a third party.
Correct.
Right?
Right.
Right.
Yes,
So,
understood.
So you had a follow-up question.
Well, my question was really was that of the two options, originally I was talking about the potential of selling the property and what would happen, and I have an understanding of that. If I don't sell the property, I guess since the statute of limitations have run out, the only recourse that they have is, as you just described, to allow the lien to persist.
Right.
And obviously, I don't want the lien to persist forever either. I feel that as long as if the equity exceeds the loan amount, then obviously I'm going to be in a worse negotiating situation.
Absolutely.
So, if I decide to stay in the home, I think that in the next 3 years I need to make it a settlement with them to obviously release it to begin with. But at this point in time, at least I think the cards are in my hands because since the statute of limitations has run out, I'm sort of holding the cards until the equity builds, and then they hold the cards.
Well, and you're right about that, but let's just go back a little bit. There's a caveat to the statute of limitation running out. Now, the courts have held that the statute starts to run from the time the bank accelerates the full balance of the loan. Now, have they sent you a letter saying, look, you're in default and now we're consider the full amount of the loan due?
Yes.
Okay, well then the statute should start running, the statute of limitations should start running from the time they sent that letter to you.
Right.
Now,
So my understanding that has run its course.
Great.
Yeah.
But I think you stated it properly in the beginning of the call, which is that's a defense to raise. So you do have to potentially be on the lookout if the bank goes ahead anyways and forecloses on the property or tries to come after you personally. So you do have to not just sit back and say, okay, it's fine, the statute of limitations has run. You might need to be raising those defenses.
It's a very tricky thing too. It's one of those defenses that if you don't raise them, you lose it.
Right.
Yes.
So
I think Jeff is got it
Sitting
on the
pretty.
ball.
I think he's on the ball. He's on the ball.
Okay, I was just trying to figure out. I mean, my main question was that was that situation of once I sell, did that change? And obviously, there is some
There's a school of thought.
Debate.
There's a debate amongst us, I can tell you that. So.
Yeah, as to whether or not. So I just have to be careful with that and to make sure that I'm making the right decision.
Right.
And otherwise, I will try to continue to negotiate with them.
All right.
And see what happens.
Sounds
but the problem
good.
is every time you go to negotiate with them, they end up. As I said, the other two loans, I got the full modification. I got the other one extinguished because they remained steady in their ownership and their servicing. This one was continually bounced around, and every time you start a dialogue, the next thing you know, they no longer are servicing it.
You have to start it all over again.
It happens.
Yeah, exactly.
We get that as well when we're settling for our clients, when we are, settling out second mortgages, when we're settling out unsecured debt. We see that. Michelle sees that. Michelle does a lot of settlements for our clients for credit card debt and that. And there'll be times when you're this close to settling and then suddenly, it's been sold. And, it's nothing personal. It gets sold in bundles of loans, gets sold in bulk. So people think, they're doing it so they don't have to settle. No, they're really not even noticing that you're in the
they're
final
not
stages.
that organized.
Yeah, they're not realizing you're in the final stages of settlement. But Jeff, you sound like you got it going on. We wish you the best. We got another call to take.
Okay, thank you all for your time.
Thank you, Jeff. Thanks for listening to the show.
Hi, Paul. Welcome to the show.
Hi, Paul.
Hi, how are you today?
Great. What can we do for you?
Well, I'm calling. I'm actually a condo board member, and I'm calling about an issue.
In a wind tunnel?
Sorry?
You might want to come off the speakerphone or something.
Something.
Yeah.
We've got a little bit.
The speaker.
Okay, Paul. So you're on a condo board.
Yeah, I'm on a condo board, and I had a question related to bankruptcy because I heard you mention that. We have a unit owner who filed for Chapter 7 bankruptcy. We were a little lax, I guess. We were giving him an opportunity to enter into a settlement agreement, but he never did, and we never filed a lien on the property. So he went and he's now filed for Chapter 7 bankruptcy. I'm just wondering what our rights are or what he's still responsible for, so on and so forth.
Well, generally speaking, the pre-filing HOA fees that were due can be eliminated in the bankruptcy. However, post-filing, that a homeowner or condo owner would be liable for the HOA fees that would accrue after the filing.
Is that post-filing or post-discharge, Michelle?
Post-filing.
Okay.
It's a post-petition debt.
Okay.
So the bankruptcy was filed in July 2013. So let's say starting August 1st, the owner would be responsible for any maintenance payments.
It was filed in July 2013. It would be whatever that date of the petition going forward, the owner could be liable. And also post-filing, those would attach to the property. Now, in a Chapter 7, they can strip the pre-filing now homeowners association if there's no equity for the lien, and there might be an issue as to whether there was a lien, in fact, anyways. But post-filing, those should be able to attach as a lien to the property, and the owner would have personal liability.
Okay, so if he filed in July and every month it's $100 homeowners association, then this guy is on the hook for at least $700, right?
Sounds like it.
And that means then, Paul, that the condominium association, if he hasn't been paying since July, certainly has a cause of action against the homeowner for the past due homeowners association fees since July.
Okay, so basically we can forget about anything pre-bankruptcy, but from the time of filing, we're owed that money legitimately, and we can now seek collections, and if we have to, send a notice of intent to lien, right?
What I would do to make sure is meet, though, with your own counsel and not do it on your own, to make sure you don't,
no, of course.
You know, that you there's no misunderstanding about what happened in the bankruptcy, to review the documents and make sure you are not violating the bankruptcy stay or the discharge of the debt that occurred in the bankruptcy. So generally speaking, there would be personal liability post-bankruptcy, but you know, definitely want to have an attorney look that over and be doing that on your behalf if you need to.
And
I looked at the public records surrounding the filing, and I noticed that his bankruptcy attorney served a suggestion of bankruptcy on any creditors that he had, including his mortgage company. I'm just wondering why he filed a Chapter 7, because usually it would be a Chapter 13, right, to try and restructure his mortgage? Because a Chapter 7 doesn't allow him to escape the mortgage, does it?
Well, the laws have been changing in regards to what you can do in a Chapter 7. So, in fact, now, currently in Florida, in the Southern District, the Middle District, you can strip liens in Chapter 7 bankruptcies where you couldn't before if there is zero equity. So sometimes you could think of that actually as a restructuring of a mortgage debt if you're able to. But it's a little more complicated than that, but we have to take a break.
Well, thank you for the question, Paul, because it brought up some interesting issues that we're going to discuss after the break.
You're listening to the Home Mortgage Law Show, brought to you by the law firm of Morris DuPont. Attorneys Will Morris, Shay DuPont, Michelle Hanash, the entire team at Morris DuPont, just one phone call away. Pick it up and dial this toll-free number, 800-974-2712. 800-974-2712. Toll-free number for a free consultation, the law firm of Morris DuPont. Much more of the Home Mortgage Law Show right after this. You're listening to the Home Mortgage Law Show, brought to you by the law firm of Morris DuPont. Our phone lines are open. We're taking calls. We want to hear from you. The experts are here. Attorneys Shay DuPont, Will Morris, and Michelle Hanash. 610 News. 866-610-6397. 866-610-6397. And I just want to take an opportunity because one of our sponsors, Regal Tax Advisory Group, they have a toll-free number too, and it's tax time. So why not get them done right? Get the most out of your tax refunds. A full-service tax preparation company. It's toll-free. 800-6000-TAX. 800-6000-TAX. That's 800-6000-829.
And I just gave Regal the last of my paperwork. So, Will,
braggart.
I'm not kidding. I'm going to get my taxes filed way before April 15th this
Really?
year. It's not going to be April 14th like I normally do.
October like I do.
At 11:59.
I have driven someone to the post office to get that return postmarked by that date.
Nope, I've been working with Regal now for 3 years. The first year, they actually amended my returns for the previous 2 years and saved me a ton of money from what my previous accountant had done. And then that first year that I worked with them, they were kind of still getting me to get my things straightened out. And I did, and I got my taxes filed at the last minute. Last year, I was even better. This year, they've got me like clockwork. I don't even think I'm going to owe anything. I think it's all going to be smooth sailing. I'm very proud of myself, and I really do think that a lot of it had to do with working now with Regal Tax Advisory Group. I really appreciate what they've done for me, for the law firm.
They're good.
Yeah, they're very good. So I can't recommend them enough. I've been using them for 3 years now. My whole family uses them, and I've been recommending them to all of my friends. And they work with a lot of our clients because they understand the Mortgage Debt Forgiveness Act of 2007. They understand how to have losses to carry forward when you get a 1099 on loan forgiveness on that investment property. They understand the issues that are raised when you've got a bankruptcy. So the Regal Tax Advisory Group, again, can't recommend them enough. It's, what is it, 800-6000-TAX?
That's it.
800-6000-TAX. Give them a call. Taxes are due. Let's get it done the right way. Michelle, I have a lot of questions regarding Paul's telephone call. Before the break, we spoke to Paul. He was on the board of directors of a homeowners association, and they had a homeowner who had owed past due HOA fees. Then that person filed a suggestion of bankruptcy. I couldn't tell if there was really a bankruptcy or not, because that's another thing that happens is people file these suggestions of bankruptcy and then they never follow through with them. So I wanted to ask about that. How do you know if someone's actually filed and gone through the bankruptcy process or not? How do you check that? And then what are the different ramifications? What should Paul and any board of directors for any of these associations be looking at when you've got a homeowner that is filing bankruptcy?
Well, Paul used a lot of words, but I think he might have been using them in some instances incorrectly. He mentioned suggestion of bankruptcy. He mentions the bankruptcy filing. The issue is that if you are a creditor of a debtor who files for bankruptcy, you should receive notice in the mail from the bankruptcy court. That is because when someone files for bankruptcy, they must list all their debt. You do not get to cherry pick which debts to include in a bankruptcy petition and which debts not to. You don't get to decide, well, I want to keep paying my American Express bill, but not my Visa bill, so I'm not going to list American Express in the petition. All debts that you owe to anyone or any entity must be listed with an address, if you can find one, so that they can have notice of your bankruptcy and they can get involved if they want to or should. Now, a suggestion of bankruptcy is a document that is filed in any pending litigation of the debtors. Because when you file for bankruptcy, the automatic stay goes into effect, which stops all actions against the debtor or property of the estate, which are certain assets that the debtor owns. So that eliminates that race to the courthouse steps that people talk about. The bankruptcy process is it's a process for the debtor to reorganize and to deal with their debts in a calm, collected, organized
way.
Exactly, not creditors running to try and collect on security interest.
Who's first at filing?
Right. Not that's also not just, we don't talk about that benefit to the creditors. There is a benefit to the creditors. Not everyone knows how to go after assets or collect on the debts owed to them. And actually, the bankruptcy process is there to make sure all creditors are treated the way they are supposed to be treated and no one gets a different preference. Right. So that is why Everyone must be listed. You don't get to choose. I hear people say all the time, I didn't include the house in my bankruptcy. That's not how you talk about bankruptcy. You have to list all your debts, and then you decide how to deal with them in the bankruptcy. So the suggestion of bankruptcy that Paul was referring to was just a notice that should have been filed in all pending
Legal proceedings.
litigation of the debtors at the time they filed for bankruptcy. And the bankruptcy filing is of public record, so that there's no secret.
Okay, is the dismissal of a bankruptcy, or if you filed a bankruptcy petition but then you didn't follow through, does that show up in the public records as well?
Yeah, there's an order. There's an order. So that you normally, we access all the bankruptcy information online through the court system, and you have to be an authorized user to access that information. But if you are a party or an interested party, not a party to the bankruptcy, but an interested party, a creditor, a co-debtor, whatever, you have some relation to the bankruptcy debtor's business, you will receive these notices from the court.
Okay, so let's say, for example, in Paul's situation, the homeowner did not list the homeowners association as a creditor, and so the homeowners association never got any notices from the bankruptcy court. They just happened to find out about it one way or another. What happens post bankruptcy? Let's say that homeowner was discharged after 3 months from their Chapter 7 bankruptcy. They completed it, and lo and behold, they did not list the homeowners association. What happens?
Well, the lien would still remain for the homeowners association on the property, so they have that recourse if they did have a lien. Now, when a creditor is excluded from a bankruptcy petition, that debtor runs the risk, and this is obviously generally speaking. I don't know what happened in that case, but the debtor runs the risk of not receiving a discharge of any debt that was not scheduled. There's an exception to that. Let's say you're in a bankruptcy, a Chapter 7, no asset case, and there's actually been no distribution to your creditors. They receive nothing, which happens maybe in the majority of Chapter 7s, the debtor actually doesn't have to pay anything to their creditors. They simply walk away from their unsecured debt. If, for instance, there was no distribution, you have a better argument that there's no prejudice to the creditor you omitted to go back in, open up the bankruptcy case, and add them for purposes of discharging the debt. But this is not something you want to be doing. You there is a remedy. If it happened, if there was an honest mistake and there's no prejudice to the creditor, usually it can be remedied. But for the most part, you want to be very careful and list all your debts in a bankruptcy petition so that you get proper notice to the creditor and a discharge of the debt.
Right, exactly.
Makes sense.
Very good. Interesting. All interesting. I always learned something new.
One more point to bring up is actual notice as well is also a defense to bring up. So if the condo association actually knows of the bankruptcy, they can't sit back and not file something. That's actual.
Regardless of how they got it.
Exactly. So it's the same in litigation.
Not necessarily.
Well,
there are certain things that says you have to, like for when you file a lawsuit, you have to actually serve the person with the lawsuit. The fact that they might have found out later on is not a defense to it.
Well, if in bankruptcy, if the creditor actually knows of the bankruptcy and they didn't receive proper notice, that still works for notice as well.
Constructive notice.
Makes sense.
Right, yeah. Well, short story is don't not pay your HOAs fees. That's the last thing you should stop payment on, because if you are having trouble making your monthly mortgage payments, or you're trying to scramble between who am I going to pay, Peter or Paul, you want to make sure you pay your homeowners association folks, because they can file a foreclosure action against you much quicker than a lender can, and the process of a homeowners association foreclosure is much faster than a lender foreclosure. There's much less options available. So if it's a choice between should I pay the mortgage or should I pay the homeowners association, the first choice you should make is call the law firm of Morris DuPont.
And that number is 800-974-2712. Patricia, I see you have a great question. We'll get to you right after the break here on the Home Mortgage Law Show. 1-800-974-2712. Toll-free number, free consultation. Morris DuPont, PA. 800-974-2712. Much more of the Home Mortgage Law Show and Patricia right after this.